Greetings. Hope everybody is safe, well, and warm. Today I wanted to talk about constitutional authority granted to Congress. The Constitution gives to Congress the power to act for the 50 Union states as an international representative and to do so without outside the boundaries of each of those 50 states. These powers are expressed in Article 1, Section 8, Clause 1 through 16, 1 full colon 8 full colon 1 hyphen 16. The Constitution gave to Congress a seat of government known as the District of Columbia. In time, Congress created a government for the district. All right, this is very important for you to grasp this concept that I speak of, because as you are well aware, there are multiple United States, okay, with multiple different jurisdictions and multiple meanings. And this district became a federal state by definition. Okay, it's telling you that the District of Columbia became a sovereign nation unto itself. Okay, however, this state, DC, is not united by or under the Constitution for the United States of America. Okay, ladies and gentlemen, it's clearly articulating to you that DC is not part of the 50 states of the Union. All right, it's its own sovereign nation with its own city, with its own rules, with its own metes and bounds that are clearly laid out with concrete pillars and stones that claim a certain bit of land being a private territory, okay? Its own entity. So has never joined the Union. Furthermore, the Constitution granted to Congress the authority to govern the district, just as the legislator of each of the several states of the Union governed their state within the geographical limits of those states. As Congress began to legislate for the district under authority of 1 full colon 8 full colon 17 and 1 full colon 8 full colon 18, the difference between the citizens of the district and the citizens of the Union became apparent. All right, now we're talking about two different classes of people, ladies and gentlemen. In that, the citizens of the district did not possess the right of suffrage or other rights. See Balzac Supra, De Lima Supra, and Downes Supra. And therefore were not recognized as part of the sovereignty of we the people. The Constitution for the United States of America provided no means of taxing these districts. Citizens of the United States, a method of forming municipal governments and of exercising taxing powers over these citizens within the territories of the United States was decided by the insular case, see Bidwell case Supra. The Constitution was made for states, not territories, wrote Daniel Webster. The Constitution of the United States, as such, does not extend beyond the limits of the state, which are united by and under it, wrote author Langdale in The Status of Our New Territories, 12 Harvard Law Review, 365, 371. The distinction between citizens of the United States and Union State citizens has been fully recognized by the Congress and the courts as follows. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the other and I'm guessing H, has citizens of its own who owe it allegiance and whose rights within the jurisdiction it must protect. United States versus Crenshaw, 92 U.S. 588, 590, and this case was in 1875. The federal government is a state. Enright versus U.S. DCNY 437 F period sup period 580, 581. Now, interesting here in the footnotes is what we're going to go over here. Domestic. In the United States, statutes mean inside D.C., the possession, territories, and enclaves of the United States, i.e., federal states. Please note that the U.S. Constitution always denoted citizen and person in capital letters until the 14th Amendment, ladies and gentlemen, where citizens and persons were not capitalized any longer. Remember in our earlier discussions, we talked about symbology and symbolism and the meanings that it has, and to pay attention to what they create and how they create it, because it's very important. The capital letter citizen symbolizes the free American man or free American people, and the lowercase citizen denotes the fact or takes away from the fact that you are free and puts you within the District of Columbia, which means that you are volunteering to participate in their system. And I won't go as far to call it fraud anymore. After doing a great amount of due diligence, I realized very quickly that they have a right to do what they're doing, but you also have the freedom of choice. And if you don't become learned and you fall within their system and you now have volunteered yourself due to your ignorance or your lack of knowledge, you've subjected yourself to their codes, regulations, statutes, and provisions, voluntarily. And so thus, equity doesn't aid a volunteer. It's not the system's fault that you have wandered around aimlessly ignorant and subjected yourself to Washington, D.C., because it is, in fact, a corporation under Title 18, 3002, subsection, I think it's B15. And correct me if I'm wrong on that. So we'll read on here. Foreign state, a foreign country or nation. The several United States are considered foreign, all right? Foreign to each other except as regards their relation as common members of the Union. Black's Law Dictionary, 6th edition, page 1407. Congress identifies these citizens of the district as individuals or citizens, lowercase c, who reside in the United States and who are subject to the district control of Congress in its local taxing and other municipal laws. In Delima Supra, the U.S. Attorney defined federal taxes with the following words at page 99 through 108. Federal taxation is either general or local. Local taxes are levied under Article 1, Section 8, Paragraph 1. Local taxes are for the support of territorial or non-state governments. Let me say that again. Federal taxation is either general or local. Local taxes are levied under Article 1, Section 8, Paragraph 1. Local taxes are for the support of territorial or non-state governments. Congress imposed a federal excise tax on the income of these citizens or individuals at Title 26 U.S.C. Section 1 as a local tax. Such taxes are not for the common welfare of the United States, but are to defray the expense of the government of the locality. And in the dual position which Congress occupies in our system as federal government and as local government for the territory of the United States, not ceded into states of the Union. It has the power to tax for local purposes. Elamio Supra, page 99. Hence, the term for source within the United States, general taxes are of two kinds, direct and what for brevity may be called indirect, meaning thereby duties, imposts, and excise, direct taxes must be laid on all the states alike. De Lama Supra, page 100. A citizen of one of the 50 states residing therein is a non-resident, non-person with respect to this local taxing power of Congress. See Bush Harbor Supra. Outside the geographical area of the United States, as that term is defined at Title 26 CFR 1.911 2G. Congress lacks power to support the local government by imposing a tax on the incomes of non-resident, non-persons, ones outside the locality, i.e. citizens of the 50 states, unless they reside within the jurisdiction by residence. See, there are certain terms that I don't like to use. Residence, what's the other one? Mailing address. These are all militarized terms. Or unless the source of their income is situated within that geographical territory. Any income arising from source therein must be withheld at the source by the withholding agent. See TD 2313, Title 26 CFR 871, and Title 26 USC 1461. Unless the recipient is engaged in a trade or business therein. For a full discussion of this local taxation, see page 55 and 99 through 108 of Delima Supra for confirmation of the domestic municipal jurisdiction of the United States. See Down Supra at page 383 through 388. Congress has control of these individuals, whether they reside within the United States, i.e. territorial states, or without the United States. These individuals, i.e. born within the jurisdiction of Congress, such as a citizen born in the District of Columbia or in one of the territories, ladies and gentlemen. Whether they reside within the United States territories without the United States, in the foreign countries as defined at Title 26 CFR 1.911-2H, or abroad, are still liable for federal income tax unless they abrogate that citizenship by naturalization or otherwise. See Title 26 CFR 871-5 through -6 and -12 and 1.932-1. However, at Title 26 USC 911A1, Congress has exempted from taxation all foreign and earned income. Ladies and gentlemen, do you earn a foreign earned income? Of these citizens individuals, except for Puerto Rico. See Title 26 CFR 1.932-1B, IRS Form 2555. Another type of non-resident, non-person are those citizens of conscious countries such as Mexico, Canada, and other foreign countries. These foreigners, residents or non-residents, as the case may be, are subject to tax on income received from any place in American Empire. All right, now let's remember the American Empire: North America, South America, Central America. All right. Australia and Austria, I believe, also fall within that. It's the United States of Canada, it's the United States of Mexico, it's the United States of America, the United States of Australia. And what's really interesting, when I started to research the seals in particular, I had a brilliant man show me this. The state registered seal so often is registered up in Canada. Trademark patented up in Canada. Why is that? What would be the need to do that in another area or alleged country? So for the Great Seal of Nebraska, it's actually found up in Canada. That's where it's registered at. Trademark registered and service marked at. Very interesting. And each element of the actual seal is individually trademarked, patented, and copywritten as well. Very, very interesting and unique. A Union State citizen, capital C in citizen, previously not non-resident, may lose his non-resident status by residing within the territorial sovereignty of the United States for 183 days. Title 26 CFR 1.8717D2 and thereby becomes subject to local tax on incomes received from source within and without the United States. Worldwide income. The income tax is a local tax imposed within the United States. The undersigned is a stranger to this locality. The definition in Title 26, the Internal Revenue Code. The definition used in Title 26 USC are very clear in defining state and United States. In every definition that uses the word include, only the words that follow are defining the term. For example, Title 26 USC 3121E1 state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. Title 26 USC 7701A9 United States. The term United States, when used in geographical sense, includes only the state and the District of Columbia. Ladies and gentlemen, the term United States, when used in a geographical sense, includes only the state with a capital S and the District of Columbia. Okay? So this makes you subject, if you fall underneath this makes you subject to statutes, rules, codes, provisions, ordinances, and otherwise of the territories and the District of Columbia. We know the District of Columbia is only a 10 square mile area. And in some research that I had read a while back, I figured out that actually George Washington removed the 4 square miles that he had donated to the District of Columbia because he realized what they were doing and didn't want to be a part of it. So he actually took back the land that he had donated to the District of Columbia after the burning of Virginia. And the reason for that was he saw what they were doing and he didn't approve of it. And so their claim to have 10 squared miles is actually facetious because they really only have 6 squared miles because the land that was once donated to them was taken back by Mr. Washington. The federal government has used these definitions correctly, but IRS agents seem to assume that they mean the 50 states of the Union, America, when they look at the word state in Title 26 USC 7701A9. You cannot use the common everyday meaning of the term United States or state when talking about the federal tax laws and many other laws that are enacted under the local municipal authority of the United States government. Another example is the Omnibus Act at 86th Congress, First Session, Volume 73, 1959, and Second Session, Volume 74, 1960, Public Law 8670 and 8624. These acts reveal the crafty way in which the federal government uses correct English and how Congress changes the meanings of the words by using its own definitions. For example, all the United States Code's definitions had to be changed to allow Alaska and Hawaii to join the Union of States united under the Constitution. When Alaska joined the Union, Congress added a new definition of state of the United States. This definition had never appeared before, to wit. Section 48. Whenever the phrase continental United States is used in any law of the United States enacted after the date of enactment of this act, it shall mean the 49 states on the North American continent and the District of Columbia, unless otherwise expressly provided. CS1, USCS 1, other provisions, emphasis added. Where it is otherwise expressly provided, answer. Section 22A, Section 2202 of the Internal Revenue Code of 1954 relating to the Missouri missionaries in foreign service, and Section 3121E1, 3306J, 4221D4, and 4233B of such code, each relating to a special definition of state, are amended by striking out Alaska. B. Section 4262C1 of the Internal Revenue Code of 1954, definitions of continental United States, is amended to read as follows. 1. Continental United States. The term continental United States means the District of Columbia and the states other than Alaska. When Hawaii was admitted to the Union, Congress again changed the above definition to wit. Section 18A, Section 4262C1 of the Internal Revenue Code of 1954 relating to the definitions of the continental United States for purposes of the tax on transportation of persons is amended to read as follows. 1. Continental United States. The term continental United States means the District of Columbia and the states other than Alaska and Hawaii. What are the states other than Alaska and Hawaii? They certainly cannot be the other 48 states united by and under the Constitution, because Alaska and Hawaii just joined them, right? The same definition applied to the Social Security Acts. So, what is left? The answer: the District of Columbia, Puerto Rico, Guam, Virgin Islands, etc. These are the states of, i.e., belonging to the United States, which is the District of Columbia, and which are under its sovereignty. Do not confuse this term with State of the Union, because the word "of" means belonging to in this context. Well, in this context, they must have some definition or a way of looking it up, because the etymology of the word "of" actually means not with. Just like when you put DE in front of something to, let's just say, defraud somebody, DE actually means no, and then fraud. So you would have no fraud. You're bringing a claim of no fraud to a court, so you're bringing a claim for which relief cannot be granted because somebody defrauded you, which means they no frauded you. All right? That's the etymology of the language and the deception within the language. It's very important. You can rip apart people's documents to the point where they absolutely make no sense, and you can defeat cases in that manner. You know, just simply using the Chicago Styles Manual, which you may or may not be able to see that, but it's there. 25. There certainly cannot. We already got that. Congress can also change the definitions of the United States for two sentences and then revert back to the definition it used before these two sentences. This is proven in Public Law 86-624, page 414, under School Operation Assistance in Federally Affected Areas, Section D2. The fourth sentence of such subsection is amended by striking out "in the continental United States, including Alaska," and inserting in lieu thereof other than Puerto Rico, Wake Island, Guam, or the Virgin Islands, and by striking out continental United States in clause 2 of such sentence and inserting in lieu thereof United States, which for purposes of this sentence and the next sentence mean the 50 states and the District of Columbia. The fifth sentence of such subsection is amended by striking out continental before United States each time it appears therein, and by striking out including Alaska. This one section all by itself contains all the evidence you need by words of construction to prove that the term United States on either side of these sentences did not mean the 50 states united by and under the Constitution. If that is not conclusive to you, then see the following. Title 26 CFR 31.3121E hyphen 1. State, United States, and citizens. A. When used in the regulation in this subpart, the term state includes in the restrictive form the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, the territories of Alaska and Hawaii before their admission as states, and, when used with respect to services performed after 1960, Guam and American Samoa. B. When used in the regulations in this subpart, the term United States, when used in a geographical sense, means the several states, including the territories of Alaska and Hawaii before their admission as states, the District of Columbia, the Commonwealth of Puerto Rico, and the Virgin Islands, when used in the regulations in the subpart, with respect to service performed after 1960. The term United States also includes, in its expansive form, Guam and American Samoa when the term is used in a geographical sense. The term citizen of the United States includes, in its respective form, a citizen of the Commonwealth of Puerto Rico or the Virgin Islands, and, effectively January 1st, 1961, a citizen of Guam or American Samoa. Emphasis added. In paragraph A, Alaska and Hawaii only fit definitions of state before joining the Union. That means the definition of state was never meant to be the 48, now 50 states of the Union unless distinctly expressed. If paragraph B confuses you, the following is submitted. The word geographical was never used in tax law until Alaska and Hawaii joined the Union, and it is not defined in the Internal Revenue Code. So we must use the definition found in the standard Random House Dictionary. Geographical, of or pertaining to geography. 2. Of or pertaining to the natural features, population, industries, etc. of a region or regions. Were you born in the United States? The preposition in shows that the United States in the question is a place, a geographical place named United States. It is singular, even though it ends in S. It also can be plural when referring to the Union States, which are places which exist by agreement. Every human in a nation is a natural citizen of a place called a nation. If he was born in that nation, those same people must be naturalized, born again, if they want to become a citizen of another nation. Original citizenship exists because of places, not agreements. This is just soil. Just Soli, Jussoli. The law of the place of one's birth. See Black's Law Dictionary, 6th edition. Now, I don't like the term birth. I don't like the word birth because birth is admiralty. It's about shipping. It doesn't have to do with a man or a woman being born alive. Here are two questions your own answer to which will solve the dilemma. In a geographical sense, where is the state of Texas located on the continent? In a geographical sense, here is the United States. Here is the United States Congress located on the continent. Where is the United States Congress located on the continent? Now, since typewriters were purchased from the area that just joined the Union, namely Alaska and Hawaii, according to Title I, Congress had to use a term that is not used in the Internal Revenue Code in order to buy the same typewriters from the same geographical area. Section 45, Title I of the Independent Office Appropriation Act 1960 is amended by striking out the words "for the purpose within the continental limits of the United States of any typewriter machines," and inserting in lieu thereof "for the purchase within the state of the Union and the District of Columbia of any typewriting machine, emphasis added. And for the declaration made under the penalties of perjury, the statute at Title 28 U.S.C. 1746 separately defines declaration made within and without the United States as follows. If executed without the United States, I declare under the laws of the United States of America that the foregoing is true and correct. If executed within the United States, its territories, possessions, or commonwealth, I declare that the foregoing is true and correct. Emphasis added. The latter clause above is the penalty clause that is found on the IRS Form 1040 and similar IRS forms, and Title 28 U.S.C. 1603A3 states as follows. 3. Which neither a citizen of the state of the United States, as defined in Section 1332C and D of this title. Section 1332D, the word state, as used in this section, includes the territories, the District of Columbia, and the Commonwealth of Puerto Rico. Examples of the two definitions of the term United States in Title 26 U.S.C. subsection 32.26 U.S.C. subtitle F 7701 A9. 9. United States. The term United States, when used in a geographical sense, includes only the state and the District of Columbia. Title 33.26 U.S.C. subtitle D, section 4612A 4A. A. In general, the term United States means the 50 states, the District of Columbia, the Commonwealth of Puerto Rico, and any possession of the United States, the Commonwealth of the Northern Mariana Islands, and the Trust Territory of the Pacific Islands, emphasis added. The Supreme Court stated that Hepburn and Dundas versus Elsley, 6 U.S. 445, 2, Cranch 445, 2L period ED 332, that the District of Columbia is not a state within the meaning of the Constitution. Therefore, it is apparent that the meaning of the term state is the first definition above can only mean the territory and possessions belonging to the United States. Because of the specific mention of the District of Columbia and the specific absence of the 50 states, inclusio unis esto, it's in Latin obviously, the District of Columbia is not a state within the meaning of the Constitution. See Humburn Supra. Therefore, the 50 states are specifically excluded from the first definition of the term United States. Congress has no problem naming the 50 states when it is legislating for them. So, in the second definition of the term United States above, Congress expressly mentions them. And there is no misunderstanding. If a statute in Title 26 USC does not have a special word of art definition for the term United States, then the first definition of the term United States is always used. See above, because of the general nature of that term as defined by Congress. When the citizen or resident of the United States are without the geographical area of the first United States, therein compensation for personal service actually rendered is defined as foreign earned income in Title 26 USC Section 911B and 911D2 as follows. 911B, foreign earned income. D2, earned income. A. In general, the term earned income means wages, salaries, or professional fees and other amounts received as compensation for personal service actually rendered, but does not include that part of the compensation derived by the taxpayer for personal services rendered by him to a corporation which represents a distribution of earnings or profits rather than a reasonable allowance as compensation for the personal service actually rendered. What that's saying, ladies and gentlemen, is when you negotiate the terms and conditions of your employment, that is considered fair trade. You're trading your time for equal value. It's an equal exchange. Thus, there is no income. There is no profit. All right. It's a fair means of exchange. So with that fair means of exchange, that cannot be taxed. All right. An income is when I buy a cell phone for $5 and I sell it for $30 and I have an income of $25. I have a proprietary gain of $25, which would be an income. Whereas when I negotiate the terms of my employment, I am negotiating a fair trade. My time for a certain amount of just compensation, which is considered a living. All right, I'm making a living. I'm not making an income. I make a living. A citizen or resident of the first United States does not pay a tax on his compensation for personal services actually rendered while residing outside of the first United States because Congress has exempted all such compensation from taxation under Title 26 USC Section 911A1, which reads as follows. 911A, exclusion from gross income. There shall be excluded from the gross income of such individual and exempt from taxation, 1, the foreign earned income of such individual. There you go, ladies and gentlemen. So fill out yourself, I think it is a W4V, a W4V for simplicity's sake. If you're good with documents, you might consider the W4T, but the W4V for the layman is probably best advised. When residing with outside the United States, the citizen or resident of the United States pays no taxes on foreign earned income, but is required to file a return claiming the exemption. See IRS Form 2555. Title 26 CFR Section 871 13C allows this citizen to abandon his citizenship or residence in the United States by residing elsewhere. Title 26 CFR Section 1.911-2G defines the term United States as follows. G. United States. The term United States, when used in the geographical sense, includes any territory under the sovereignty of the United States It includes the states, Puerto Rico, Guam, Mariana Islands, etc., the District of Columbia, the possessions and territories of the United States, the territorial waters of the United States, the airspace over the United States, which, ladies and gentlemen, let me direct you to something here. Man was given dominion over the land, air, and water. And what happens so quickly is overzealous men form a corporation and decide that they want to usurp power otherwise not delegated to them and lay claim to our land, air, and water, ladies and gentlemen. It's absolutely egregious that we would agree to that, because when you have the true book, the original book of trust, and you can walk into one of those courtrooms, you can clearly articulate and show the first constructive trust ever made was by the heavenly creator giving man dominion, all right, control, okay? And the seabed and subsoil of those submarine areas which are adjacent to the territorial waters of the United States and over which the United States has exclusive rights in accordance with international law. Well, international law doesn't, unfortunately, coincide with natural law and God's law, does it? All right, so we have a conflict here, and you have to make a stand and a statement. Look, there's no way you or a body of politic can own or control anything because you didn't pay for it. One of my favorite movie scenes is where they got a train sitting on the tracks, and the Indian's sitting with two Europeans, and the European says, "We'd like to give you some land." And the Indian says, "Well, we already have land." And he says, No. We'd like to give you some land to live on because we now own the land that you're on." And he says, "Well, who did you get the land from?" And he says, "Well, we didn't get it from anybody." "Well, who did you pay for the land?" He says, "We didn't pay anybody for the land." He says, "Well, then how are you going to sell me or give me land that you don't own?" He made a very poignant point there. Mother Earth was given to us, all right, and we are allowed to utilize that land mass and to grow food, and we're supposed to flourish and multiply, and we're supposed to take care of our neighbor and take care of one each other. With the body of politic here, these guys are all about war. They're warring on God. They're warring on the Creator by claiming things that do not belong to them. A body of politic, a group of men have usurped power otherwise not delegated to them by threat of force. All right? That's it. That's ultimately what sovereignty boils down to, is who's got the bigger gun and who's a better shot. And to prove my point, that's how brutal common law was back in the day. If you couldn't solve your dispute in court, then you went out and you stepped off 25 paces and you did a duel in the street. Now, the winner of that necessarily wasn't right, may have just been a better shot, a little faster on the trigger, whatever the case may be, rather cruel. And that's why common law is so brutal. When people say, "Oh, I want common law back," common law is extraordinarily brutal. And common law, although good in some aspects, is not the answer for all situations. All right? But natural law, however, is. Do no harm, don't steal, lie, loot, pander, and thieve. Don't deceive people through a manipulation of language, which is what I'm trying to show you here. There are multiple definitions for the United States. There are multiple definitions. You got the United States of America, you got the United States, you got the all caps United States of America, you've got the one that was created by the Irish Reich, known as the United States. You got King George's United States that was created in 1302. Okay, it was a corporate charter. It was a public corporation, ladies and gentlemen. So everybody thinks the United States of America was founded in 1776, but in all actuality, it was founded clear back in 1302. George Washington was not the first president of the United States of America. It's your history books lie to you so much that you can't make up heads or tails of what's true and what's not without doing an abundant amount of self-educating. Because these are things that are not found in your history books. Remember, in the public school system today, you have a bunch of bureaucrats, legislators, who are lawyers, who are personally molding and structuring the literature that goes within your school system. You're not learning about this in school. When in school, did any of you learn there are multiple definitions for the United States because there are multiple United States charters? Nobody ever told you that in high school. Nobody ever told you that in grade school. So let's continue on. All of the 50 states are formed with respect to each other and are under the sovereignty of their respective legislators, okay? Except where a power has been expressly delegated to Congress. The citizens of each United States are foreigners and aliens, all right, with respect to another union state, unless they establish a residence therein and under the laws of the union states. All right, the union states is where you want to be, ladies and gentlemen. You don't want to be part of the United States under Title 28, subsection 3002-15. You don't want to be there. All right, that's a voluntary land where you voluntarily suffer for your lack of knowledge. All right. Otherwise, they're non-resident, non-persons. Very important. If you're a resident, you fall within the District of Columbia and its territories. If you're a person within the scope of the District of Columbia, which they have jurisdiction over, all right? This is very interesting stuff. I'm not a person, I'm a man. There's a difference. Could I control a person? Absolutely. Can I utilize a person to conduct business if I choose to do so? Absolutely. We find that in Article 1, Section 10 of the United States Constitution. Also, we find that in Article 1, Section 16 of the Nebraska Constitution, the unalienable right to contract, okay? With respect to all the other union states. The regulation at Title 26 CFR Section 1.1-1A state in pertinent part, A, General Rule 1, Section 1 of the Code imposes an income tax on the income of every individual who is a citizen or a resident of the United States. Okay, they're talking about the Title 28, subsection 3002-15. That's the person they're talking about making an income. That's that paper entity that you utilize making the income that they're taxing, okay? To the extent provided by Section 871B or 877B on the income of a non-resident alien individual. Title 26 U.S.C. Section 1 imposes a tax on taxable income as follows in pertinent part. There is hereby imposed on the taxable income of every married individual. All right, once again, what'd you do? You got a damn marriage certificate, a marriage license, and you subjected yourself to Title 28, USC 3002. You're a voluntary subject and participant, a willing participant of a corporation identified as the United States, and thus you fall subject to the statutes, codes, provisions, city ordinances, and municipal codes that you volunteered to subject yourself to. Who makes a single return jointly with his spouse under Section 6013. Now, you can't just find this literature anywhere. This was sent to me by an extraordinarily brilliant man who put this together of his own free volition, who has scrupulously went through the books and is trying to help me see a little better what truly is happening. And I'm very appreciative of this knowledge that he has given. I know everybody's going to ask, where do I find this? How can I get it? This is not my intellectual property. I did not create this. This came from another man. I'm blessed to be able to share it with you. And so take it for what it's worth and take the time and go evaluate these codes for yourself. The regulations promulgated to explain Title 26 USC Section 1 are found in Title 26 CFR Section 1.1-1 and state pertinent part. A, General Rule 1, Section 1 of the Code imposes an income tax on the income of every individual who is a lowercase c citizen or resident of the United States, and to the extent provided by Section 871B or 877B on the income of a non-resident alien individual. Please note that the term taxable income is not used as such in the above statute because the income of those classes of individuals mentioned is taxable as taxable income. Section 1.871, Classifications and Manner of Taxing Alien Individuals. This term state, notice how it's a lowercase state, evidently does not embrace one of the 50 states where I am a free inhabitant, united by the Constitution, all right? Because a separate governments or foreign states with respect to the United States, i.e. D.C., its territories, possessions, and enclaves. A. Class of alien. For purposes of income tax, alien individuals are divided generally into two classes, namely resident aliens and non-resident aliens. B. Classes of non-resident aliens. 1. In general, for purposes of the income tax, non-resident alien individuals are divided into the following three classes. Non-resident alien individual who at no time during the taxable year are engaged in a trade or business in the United States. Are you in Washington, D.C. and its territories when you're doing business? Do you know the difference? Do you know who you are and how you operate? Okay? Are you operating in a private nature? Or are you operating in a public capacity found within the territorial jurisdiction of Washington, D.C., which is a 10 squared mile area that has metes and bounds and 4 cement stones in place to show you where it's at? All right? Physical boundaries. 2. Non-resident alien individuals who at the time during the taxable year are or are deemed under section 1.871-9 to be engaged in a trade or business in the United States. And 3. Not applicable. Concerns residents of Puerto Rico. You notice how they always say residents of Puerto Rico, they call them United States citizens. They say that no U.S. person lives in the outer minor lying islands. If you've ever done your research, you can see that. 43.26 CFR section 871-13 states as follows. A, in general, an individual who is a citizen, lowercase c, or resident of the United States. So what are we talking about? Title 28, subsection 3002-15B, I believe is what it is. Correct me if I'm incorrect on that. But states that the United States is a federal corporation. At the beginning of a taxable year, but a non-resident alien at the end of the taxable year, or a non-resident alien at the beginning of a taxable year, but a citizen of, or resident of the United States. And remember, resident is your telltale sign that you're back within the confines and the jurisdiction of Washington, D.C., all right? United States at the end of the taxable year is taxable for such years as though his taxable year were comprised of two separate periods, one consisting of the time during which he is a citizen or resident of the United States, and the other consisting of a time during which he is not a citizen or resident of the United States. Isn't that interesting? Non-resident alien. The federal income tax is a local tax for the United States to support local municipal governments, and in order to become liable to this tax, a state citizen must be a resident therein, i.e. a resident alien, or receive income from sources therein, or to be engaged in trade or business therein. In Title 26 U.S.C. Section 7701 B1A and B, Congress defines the statutory difference between resident alien and non-resident alien as follows. B. Definition of resident alien and non-resident alien. 1. In general, for purposes of this title, a resident alien, an alien individual shall be treated as a resident of the United States with respect to any calendar year if and only if such individual meets the requirements of Clause 1, 2, or 3. Lawfully admitted to for permitted residence. Such individual is a lawful permanent residence of the United States at any time during such calendar year. 2. Substantial presence. Such individual meets the substantial presence test of paragraph 3. And 3. First year election. Such individual makes the election provided in subparagraph 4. B. Non-resident alien. An individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States within the meaning of subparagraph A. All right? The undersigned is not a resident, as the term is defined in above statutes, nor citizens of the United States. The undersigned is a non-resident alien, as that term is defined in subsection B, and has the same status as the plaintiff in Burshabar, B-R-U-S-H-A-B-E-R, Supra. Individuals required to make returns of income. The following individuals are required to make returns of income. Title 26 CFR Section 1.6012 1, individuals required to make returns on income. A. Individual citizens or residents. 1. In general, an income tax return must be filed by every individual if such individual is 1. A citizen of the United States, whether residing at home or abroad. 2. A resident of the United States, even though not a citizen thereof. Or 3. An alien bona fide resident of Puerto Rico during the entire taxable year. The undersigned clearly is not defined in the above statute, but is defined in the following statutes as one who is not required to make a return. Title 26 CFR Section 1.6013-1 states, B. Non-resident alien, a joint return shall not be made if either the husband or the wife at any time during the taxable year is a non-resident alien. The undersigned is a non-resident non-person with respect to the United States with no income derived from the source within the United States. Title 26 CFR Section 871-7 states in pertinent part as follows. Except as otherwise provided in Section 1.871-12, a non-resident alien individual who this section applies is not subject to a tax imposed by Section 1 or Section 1201B, but pursuant to the provisions of Section 871, A, is liable to a flat tax of 30% upon the aggregate of the amounts determined under paragraphs B, C, and D of this section which are received during a taxable year from sources within the United States, emphasis added. Please note, Title 26 CFR Section 1.871-4B, proof of resident of aliens, which establishes a key legal presumption. B. Non-residents presumed, and alien by reason of this alienage is presumed to be a non-resident alien. 52. Further facts are illustrated by the definition of withholding agent at Title 26 U.S.C. Section 7701-A16. A withholding agent, the term withholding agent, means any person required to deduct and withhold any tax under the provision of Sections 1441, 1442, 1443, or 1461. Title 26 U.S.C. Section 1441 refers to the non-resident alien who received income from source within the United States, as set forth in Section 871A1. These sections do not apply to the undersigned. The undersigned has not had taxable income to present, and I do not foresee any taxable income in my future. Your attention is invited to Title 26 CFR Section 31.3401A6-1B, which states as follows. Remuneration for services performed outside the United States. Remuneration paid to the non-resident alien individual for services performed outside the United States except from wages and hence is not subject to withholding. Emphasis added. As a rule, military retirement pay of non-resident alien individuals is exempt from the income tax at Title 26 CFR Section 31.3401A-1B1-2 with the following exemption. Where such retirement pay or disability annuity is paid to a non-resident alien individual with withholding is required only in the case of such amounts paid to a non-resident alien individual who is a resident of Puerto Rico. And Title 26 CFR Section 935-1A3 for special rules for determining the residence for tax purposes of individuals under military or naval orders, see Section 514 of the Soldiers and Sailors Civil Relief Act of 1940, 50 APP, USC 574, the residence of an individual and, therefore, the jurisdiction with which is he required to file an income tax return under paragraph B of this section may change from year to year. Section 571 of the Soldier and Sailors Relief Act states that for the purposes of taxation in respect of the personal property, income or of any such person by any state, territory, possession, or political subdivision of any of the foregoing, or the District of Columbia of which such person is a non-resident or in which he is not domiciled, personal property shall not be deemed to be located or presented in order to have a situs for taxation in such states, territory, possession, or political subdivision or district, emphasis added. And with that, ladies and gentlemen, I'm going to let you go here. I'll read this last part. When the undersigned received the initial correspondence, a copy of the district director in Kansas City, Missouri, no rebuttal has been received. The time for rebuttal has elapsed. See Exhibits 4 in conclusion. See Exhibits number 4. If there is any confusion to the readers of this documentary evidence, please do not try to explain the content of the dissembled income tax rule and regulation to me. Let me look at something here. I just want to make sure this gent's name isn't in this because he is on the private side and wishes to remain private. I'm going to stop there. I may come back with the conclusion of this document at the end. I need to go through it and make sure that this gentleman's name isn't in the document further because the 15th page, I think there's 15 or 15 pages here. And so I just want to make sure that his name's not in there. Anyway, thanks for joining me. I hope that helped you understand that there are multiple definitions of the United States. The man is absolutely brilliant. This is not a book. This is not something you can find out there. This is something that he took his time, put his equity within, and was generous enough to share with me to help open my eyes to the reality of what's truly transpiring. And in conclusion of reading this, you can definitely conclude that there are more than one United States. There's more than one United States of America. There are multiple charters out there, and they're using a form of written deception that takes you away from where you really want to be. And in order to be there, you have to be learned enough to understand when you're operating within a certain territorial jurisdiction, otherwise identified as Washington, D.C., and when you have removed yourself from it, when the Constitution applies to these agents and agency. I keep hearing people say, I have constitutional rights. I have unalienable rights, and the Constitution limits the government from the encroachment upon those rights. All right, ladies and gentlemen, I don't have constitutional rights. A piece of paper never gave me my rights, ladies and gentlemen. I was born with them. For all men are created equal, all right? Because no man created himself. Thank you very much for joining me. I'll get back to you a little bit later. This was just a video, again, to show you the difference between the United States, the all caps United States, the territories of the United States, the difference between Puerto Rico, Guam, the Samoan Islands, and, of course, the Union of States, which nobody really talks about. So with that, thank you. Have a beautiful, blessed day. I hope this video helps you and finds you well. Share it with your friends and family. Help open their minds. This is a period in time that is so great. One, because we can have an ascension of the mind. The masses can get together and start to really decipher what has been done through the manipulation of language, and we can correct what has been done, ladies and gentlemen. And the only way we correct it is with the ascension of the mind, the gain knowledge, and sticking together. It starts with working within our communities. You're not going to change Washington, D.C. If this document didn't show you that Washington, D.C. is its own corporation, they're going to make their own damn rules, they're going to do whatever they want because they're well within their rights to do so. If this document didn't show you that, then I don't know how to help you. Because the only difference you can make is within your local community, all right? And get back to the Republic, get the people back to being educated so they can make sound decisions for their family, their friends, their community, and help one another grow. Thanks again for joining me.